Welcome to episode 46 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. I think this is kind of cool that we're going to get to episode 50 and then we're going to be um, able to leave our houses. Um, I've been asked by a couple people who have listened regularly what I'm going to do once we are back in our brick and mortar office. And, for those of you who have been here from day one, you know that this started sort of as a joke. And then we had so many people interested after the first three that we just continued throughout the whole time that we've been under the stay at home order. So, we may just change it to 5 reasons not to harm your loved ones and take out the quarantine and start over with relevant topics that people just want information on. It's we're working back into our reopening plan, um, and so I'm hoping that on that next week you'll actually see me in my office, not on my front porch. I don't know if it will really happen that quickly, but that is what I'm hoping for right now. Um, and it is an absolutely beautiful day here today, Brenda. It's actually going to be 90 and it's sunny and it's really, really lovely outside. You can hear the birds in the background. Uh, and and I especially appreciate you listening because you have a time change. And so it's, well, it's not that early there, but it's certainly earlier than 1 o'clock that it is here. So let's talk about Michigan opening and what that means. We have officially moved to phase four um, of the governor's 6 phase plan, and that is the improving stage. Um, so basically, stay at home is recommended but not required. She's allowing most businesses to reopen within the next week or so. And the businesses that can't reopen are basically businesses or places where people gather in close proximity to each other. So whether it's close proximity because of the activity or because of the service. So, like amusement parks, arcades, bingo halls, the non tribal casinos, those are not opening. Um, Tattoo parlors, bowling alleys, indoor climbing facilities, indoor dance facilities, exercise studios, gyms, fitness centers are not opening. Hair salons, nail salons, massage parlors, piercing, tattoos, personal care, spas are not opening. Theaters aren't opening. Trampoline parks aren't opening. Racetracks are not opening. But retail, restaurants, outdoor fitness, house cleaning, drive-in movies, offices, day camps, and graduation parties are all a go as long as people are wearing masks, social distancing, and there are no more than 100 people at a time. So we are moving ahead, which is really exciting. Our numbers for today, we have 57,532 cases in Michigan. That's up 135 um, in a day. And we have 5,516 deaths, which is up 25. And it's really interesting if you some of the different ways they're showing the statistics now because they have more time, I guess, to calculate them and graph them. um, it's really interesting, and you'll see that on one of the charts I looked at this morning, they had it mapped out by age, and it's not so much that people who get it are older. It's more that people who die from it are older. And so that was all really, really interesting. So moving out of our COVID update, and today is part 3 of our 5 part series on abuse and domestic violence. So I just wanted to tell you a little bit about where we've been if you haven't watched part 1 and 2, and where we're going today and in the couple days to come. So the first day we talked about basically that domestic violence and abusive behavior is not always something we can see with bruises and cuts and broken bones. And that we talked about the different kinds of abuse: emotional, financial, isolation, social abuse, as well as physical abuse and sexual abuse. We talked about the growing number of cases that have emerged since COVID-19, especially between parents and children, and not necessarily the parent being arrested, but in many cases, the child being arrested for assaultive or rebellious behavior towards their parents. Um, so that is, and yesterday we talked um, about the yesterday we talked about the different kinds of abuse and ways to just ways to recognize them, as well as we talked about some resources yesterday. Not a lot because we're going to get to those tomorrow and the next day, but we had a good discussion yesterday about why and how crime has dropped drastically across the country, but domestic violence and child abuse are definitely on the rise. And so that was basically the premise of yesterday. So today we're going to talk about the like all the crimes that are kind of under this umbrella of family violence or family abuse. And and you have to understand that when the crimes are named or defined, they're legal terms of art. It's not necessarily, a lot of people will say, oh my God, they have, you know, crazy house. I'm sure there's domestic violence there. Um, in the legal definition, it doesn't just mean that someone's in danger. It can, and it doesn't just mean that someone's been hit. It could be that someone is just in danger. Um, so there are different ways to look at it. So the basic definition is that domestic acts of domestic violence include many different forms of criminal behavior, and it can include any assault, which is putting someone in imminent fear of being harmed; an assault and battery, which means that they actually there is an unconsented physical contact; and aggravated assault, which means that there was that physical contact that um, caused an injury. Even murder may be characterized as domestic violence. Domestic violence is not a specific crime, but it's a description of circumstances surrounding a violent crime where the perpetrator has a relationship with the victim. And that relationship is what's called a domestic relationship, and that is what moves it from assault and battery to domestic violence as the way it's charged. The domestic relationship has been defined as anyone who lives in your home, anyone who you have been in a relationship with, past or present. Um, a, it could be a relative who's lived in your home. It could be a significant other. It could be anyone who really has ties to you, emotionally, or had in the past, or to your physical space. That would be my easiest way of explaining it. Some of the crimes that we see um, are arson, assaults on a person, cruelty to animals, cyberbullying. Those are just a few. Under the assaults, we have the felony assaults as well as the misdemeanor assaults. The misdemeanor assaults are domestic violence, assault and battery, aggravated assault. Um, the felony assaults are felonious assault, which is when someone is harmed with a weapon. It doesn't have to necessarily be a weapon like a gun or a knife. It could be anything that is being used as a weapon. So our appellate courts have decided things like a boot could be a weapon. A frying pan can be a weapon. A car can be a weapon for purposes of felonious assault. It doesn't have to be just your standard um, weapons, firearms, things like that. It could be a normal household thing that's being used uh, to cause fear in another person. Um, we also have that's a 4-year felony, and then there's assault with intent to do great bodily harm less than murder, and that is when you don't necessarily have something being used as a weapon, but you cause grave physical, not grave physical injury, but you cause serious physical injury. So this is the instance where, there's a fight and one person just beats the crap out of the other person. Um, there's a lot of other descriptions or fact patterns that fit there, but that's the one we see most often. Next would be assault with intent to murder, and that's when someone engages in an activity that is likely to cause death, but it doesn't. So, for example, if someone were to throw a Molotov cocktail, otherwise known as a firebomb in a pop bottle, um, through a window of a home, and the person didn't die, that person could be charged with assault with intent to murder. And then you obviously the other assaults all have to do with where someone has died, and that would be involuntary manslaughter, voluntary manslaughter, and then first and second degree murder. We also have the defined crimes in the family violence area of cruelty to animals, and that is when willfully or maliciously and without just cause an animal is killed or tortured, mutilated, disfigured, or poisoned. There's also a flip side of that that deals with neglect. Some of the other crimes, like I said, arson, there's different degrees of arson depending on what the igniter is, as well as what the accelerant is, as well as the damage that's been done. We also have kidnapping is also a form of family violence. We've seen, unfortunately, a rise in our family law cases of parental kidnapping in recent weeks, and um, parents are at risk of being charged with parental kidnapping if they violate the parenting time order, especially if they just withhold the child or leave the state with the child without having any communications with the other parent. Obstruction of justice is another one that we see occasionally, very rarely, but we do see that. And then there's also an offense that if someone is involved in an assaultive interaction and they're pregnant and the pregnancy um, there's injury to the fetus or injury to the mother or something causes a miscarriage or a death or a stillbirth, that is also in this category of family violence offenses. It's the prosecutor's discretion what to charge, and way back in, I want to say it was probably the episodes in the early 20s, late teens, we talked about how someone is charged and about investigations and things like that. So that is, if you want to hear a lot about that, we can go back to that time. Um, if someone is arrested for any assaultive crime and they are not a U.S. citizen, more than likely, ICE, the Immigration and Customs Enforcement at the Department of Homeland Security, is going to be called. And even if they're released on a bond for their crime um, that they're being arrested for, they may not be allowed to be released if because ICE has the power to put a detainer on anyone accused of a crime of violence who's not a citizen. Oh, on the relationship, I just realized I forgot to say this. On the relationship status that brings them into this category, any two people that have a child in common, even if they haven't spoken since the child was born, it would fall under this category if there was some, illegal conduct between the two people. There are penalties for each of these offenses, and then there are enhanced penalties. Um, Basically, um, assault and battery or domestic violence is for first time offenders is a 93-day misdemeanor. That doesn't mean you go to jail for 93 days. That means the worst possible thing that would happen would be going to jail for 93 days. You could be given a fine of not more than $500 or both. You can be put on probation. You can be forced to go to batters counseling. You can be forced to do drug screens. You can be monitored by the court for up to 2 years. First-time offenders have the option of, if the prosecutor and the judge allow it, of having their plea taken under advisement under a sentencing statute that is MCL 769.4A. If you're not familiar with that, it basically says this is the first time that you've ever been involved in an assaultive offense. And, sometimes these things are just, get out of control faster than you can control them. So we're going to give you this break where if you complete all of the court ordered requirements, then we're going to dismiss the case and you won't have a conviction. What people don't realize is that the case is being dismissed. That means that the arrest will still be on their record. And they won't have a criminal record, but that arrest will still be there. Victims of domestic violence have to pay restitution usually. It could be any uninsured medical costs, costs of therapy, costs of any sort of recovery assistance that the victim is in need of in order to heal from the assault. Of course, restitution and the person being called a victim, none of that happens or kicks in unless there is either a finding of guilt or an admission of guilt, because the person who is arrested is presumed innocent until proven beyond a reasonable doubt otherwise. People who are accused of domestic violence are entitled to a jury trial and or a bench trial if the prosecutor agrees to waive the jury. There are some enhanced penalties for repeat offenders of domestic violence, and on their second offense, meaning they have one prior conviction, then the maximum penalty will go from 93 days to 1 year, and the fine will go from $500 to $1,000. If someone has committed 2 or more prior convictions, which means this is their third, their sentence can now be, and their charge will be enhanced to be a felony instead of a misdemeanor, and it's imprisonment for not more than 5 years or a fine of not more than $5,000 or both. So what that means, in the same way that we talked about with the 93 days, it doesn't mean you're going to jail or prison for 5 years. And we did talk early on, I think it was in week 1, beginning of week 2, about the difference between jail and prison, if you want to go back to that. Then 5 years is the max amount of time that a person could serve. There is no requirement that the prior domestic violence was with the same victim. It could be with anyone. And basically, everything can be enhanced if there was a more serious injury, if there was a weapon, all of that can enhance your penalty and your charges. So most people are put on probation. there is and part of the probation, if it will be no contact with the victim, and that is, any contact. You can't send flowers, you can't go to the house because you had to get your clothes, you can't send snail mail, you can't send packages, you can't send email, you can't text. The only exception, but it has to be accepted in a court order, is if you need to communicate to effectuate parenting time with the person. That is it. If you miss the drug screen, that's considered a violation. If you don't go to batter's counseling, that's a violation. That can give you up to 30 days at a time of probation. I'm sorry, up to 30 days in jail as part of your probation for the technical violation. If you have a non-technical violation, means you committed another assaultive crime, for example, then you can be put in you can be put in jail for up to the maximum for the offense that you have been convicted of. So if you're convicted of the felony, it could be up to 5 years. If you're convicted of the domestic violence first time misdemeanor, it would be up to 93 days. And those are basically the reason that those penalties are so harsh and are enhanced when there's a violation, because judges really feel like when you violate your probation, things that you have to do, things that will put your life back in order, that you either don't care about yourself or you don't care about the court. And it's taken very, very, very seriously. So the other conditions of probation that a judge can order are anything that is appropriate for your individual case. They can order boot camp. They can order individual therapy in addition to the batter's counseling. They can really, the sky's the limit. It really just depends on the facts of the case. A lot of times, if there's children involved, there's going to be parenting classes and family counseling also put in there. As we talked about a little bit yesterday, warrantless arrest is not only allowed but encouraged in the domestic violence arena, and that when the police respond to a home, if they have reasonable cause to believe, it's very, very little amount that a violation has occurred, and they already have that when they get the 911 call that says, that X is happening, and that they have that domestic relationship. So child in common, reside in the same home, dating relationship, former dating relationship, spouse, former spouse, all of those things. So that's all it takes for a person to be arrested for domestic violence. There is policy in many, many jurisdictions. I actually don't know of any that don't have the policy that someone must be arrested as a safety measure to protect the uh, the the victim, as well as to protect the peace of the community and of other members in the household. So another offense that I want to talk about for a minute is stalking. Stalking goes hand in hand with domestic violence because stalking is a repeated or continuing course of conduct where it causes another person to feel terrorized or frightened, or feel terrorized, frightened, intimidated, threatened, harassed, or molested. And so basically, it's unconsented to contact. So we've already talked about unconsented to contact it can be a battery if it's physical contact, and it can be an assault if it's not. It can, and if the person has said, no, stop communicating with me, leave me alone, I don't want to talk to you anymore, no, just get out of my life, no, whatever, then that can kick in the stalking statute if there's a continuing course of conduct. Basically, if there is one instance, then that would be the misdemeanor, and if it's repeated, then it could be a felony. As I said, the prerequisite though is for the person has to say no, that they don't want the contact, they don't want the visit, they don't want the email, they don't want the text. It has to say no. So a person is guilty of stalking if they if you're convicted under the stalking statute, you're guilty of a misdemeanor, as I said, which is punishable by imprisonment of not more than 1 year, fine of not more than $1,000, or both. If you're convicted of felony stalking, then it's 5-year felony, fine of not more than $10,000, or both. If the victim is less than 18 years of age at the time or during the course of conduct, the individual is 5 or more years older than the victim, so there's 2 different ways that can kick in, then it will be a felony. Okay. You can be on probation for a term of up to 5 years, and you have to, of course, refrain from contact, refrain from stalking, and usually some sort of psychological evaluation or social evaluation. If it's a sexual assault, it will be a psychosexual evaluation. If it's a child involved, it will have some child abuse testing done, the propensities and indicators to determine what is appropriate. Some defendants run into trouble when these types of evaluations are ordered, because if they're court ordered, insurance doesn't pay, and so it would be an out-of-pocket offense. An out-of-pocket expense on the part of the defendant. Another area that falls in here is child abuse. There are 4 degrees of child abuse. First degree being the most serious, and that is when you have serious physical harm or death to a child. That could be a sexual assault. That could be if a child is severely burned. It could be where they're physically harmed, where they have probably it could be a broken bone, but usually in order to be at first degree, it would be where they have multiple broken bones. It could be a combination of all of the above. As I said earlier, child abuse and abuse in general are not always physical. Sometimes they're emotional. Sometimes they're isolating. Sometimes they're just about power and control. So most of those that don't have physical injuries would be in the second degree child abuse category, with the exception of and the fictitious disorders, which are basically usually it's moms. So I'm just going to use them as the defendant in the example. They have attention-seeking needs, and so they exaggerate symptoms that their children has. They create symptoms in their children so that they can then take them to the hospital, where they are given medical treatment that they may not necessarily need. It's using the medical community as a weapon, essentially, and harming your child. That would fall in the first degree category most of the time. That used to be known as Munchausen by proxy, for those of you who have followed kind of the evolution of child abuse, but we don't call it that anymore. The third degree child abuse can be the less serious physical injuries, or or it can be, emotional or other types of abuse. And fourth degree also can be, very minor injury. But what differentiates the first degree to the fourth degree is intent. So it's an intentional harm in the first degree. It could be um, like negligence that can cause fourth degree. So, obviously, if you leave your front door open and your 2 year old wanders out in the street, and a police officer sees your child out there, but they're not harmed, that could be fourth degree child abuse because it was negligent to leave the door open and it was negligent to not be supervising your child properly. That's just an example. Sometimes we see that what comes in, as it depends on the facts, but second, third, or fourth, but usually third or fourth, are those cases where the parent leaves the child in the car, and runs into the mall, runs into McDonald's, runs into the vet, runs into the bank, those kind of stories. So that's really what the child abuse statute says. As far as punishment, child abuse fourth degree is a 2 year, it's called a high court misdemeanor. We've talked about those before. Basically, misdemeanors are defined as anything punishable by more than 1 year. I'm sorry, less than 1 year. And felonies are anything that is more than 1 year. In these high court misdemeanors, basically it's classified as a misdemeanor, but it's treated like a felony. So you have the the constitutional rights and the due process that you would get if you were charged with a felony, even though it has this label of high court misdemeanor. It's highly, highly confusing, and it usually comes back on a background check as a felony, and that messes people up all the time. The child abuse fourth degree, as I said, it's a 2 year max, and it can have all kinds of conditions. Often, when someone is charged with child abuse, there will be an accompanying child protection proceeding, where where the Department of Health and Human Services, Protective Services, is seeking to monitor and supervise your home during a period of time to make sure the children are safe. Or if the children are removed and with a relative or in foster care, they'll work on a reunification plan, or they could try to terminate your parental rights if you're charged with first or second degree. So there's a lot of different crossover, and you can be defending these types of cases on both those fronts at the same time, including if there's a divorce or a custody proceeding, you could be fighting it there too. There is no, people always say, like, I'm charged criminally, and the child protection case is based on the alleged criminal conduct. Shouldn't that be resolved first? Well, the law says no. The law says that children need permanency, children need stability. So that's the goal of the child protection proceeding. The goal of the criminal proceeding is punishment. So it's really discretionary up to the judge in the child protection case or in the custody case to, um, they can say, yep, we're going to wait, or they can say, no, we're going forward. It makes it very, very difficult to defend if we have to do one of those, the family type cases first, because in the family cases, the accused can, if they take the fifth, it has a negative connotation and a negative inference, and the judge can assume that if the defendant or the accused or the dad or the mom, whoever it is, had taken the stand and had testified, they would have hurt themselves. Where in a criminal case, if the accused takes the stand, they're not allowed to make that inference. You have a right to remain silent, and so your silence can't be used against you in a criminal proceeding. So that's one of the parts that we have to litigate often, is we always, always, always want our criminal case to go first. And sometimes how we do that is by making really creative suggestions as conditions of the defendant's bond. So, for example, if Protective Services wants in and they want authority over the family because because they're afraid that the children are in danger, and we want that case to be on hold, we can offer to have a provision put in the accused bond that says that they will fully cooperate with protective services and engage in any recommended services or programs. So there has to be a lot of communication between all the parties. As I said, these are very challenging to defend because you are different. You have all different things. You have different burdens of proof, different rules of evidence, different proceedings, different judges, and different rights. So it actually takes more evidence to be convicted of a crime than it does to lose your parental rights. So it's important when people are involved in that. We always try to, I mean, my favorite is to be involved while it's still under investigation so I can control what's happening when a little bit, or at least say my piece and try. But certainly we don't have that luxury most of the time. And people don't realize they need us till they really need us. But we always try to take that kind of multi-path defense and coordinate it into some uniform strategy to achieve our clients' goals. And that's really the best way for it to be handled. Um, I didn't talk about aggravated stalking when we were talking about stalking before. Aggravated stalking is a felony. It's punishable by up to 5 years and a fine of not more than $10,000. And it basically, the court can keep the person on probation for up to 5 years. And also, hold on one second. And that is the situation where the individual has um, has at least one of the actions constituting the offense is in violation of a restraining order, and the individual has notice of that restraining order. And the restraining orders in Michigan that they're talking about can come in the form of a restraining order that's in a judgment of divorce, a restraining order that's in a temporary order within a divorce or a custody or support proceeding or a paternity proceeding, or it could be in the form of a personal protection order, which we're going to talk about in a minute as our last thing for today. Oh, actually, we probably should wait and talk about that tomorrow because we're at 37 minutes. I guess I'll defer to you guys to tell me if you want out. Um, so the other things that can cause a person to be charged with aggravated stalking as opposed to regular stalking are if they are in violation of a condition of their probation, a condition of parole, a condition of pretrial release, or a condition of bond. Um, so that can aggravate the conduct to be aggravated stalking and become this more serious offense. Also, if the course of conduct includes the making of one or more credible threats against the victim, a member of the victim's family, or another individual living in the same household as the victim. So remember, we talked about that the misdemeanor stalking is kind of the first time that it can be the whole chain of behavior, but it's the first time the behavior happens. If it happens again, then it will be the felony aggravated stalking. And so basically, with the exception of, I mean, there's all kinds of things we could talk about as far as offenses because they're really fact driven. But just quickly to talk about preview for tomorrow, um, we will talk about PPOs tomorrow, and I also want to talk to you about witness tampering and some of the nonsense that goes on in the background um, when the people involved realize how much trouble their person is getting into. The recantation, the I don't want to prosecute, but it really did happen scenario. Um, and if we have time tomorrow, we'll also talk about some of the services that are available to um, to people who have been victims. And then on Friday, we'll go into some of the services and supports that are available for people who commit violence against their family members. And we'll have a Q&A. So I'm going to ask any of you who do have questions or anything that you specifically want to know about domestic violence to either post it on the Facebook page or private message me or reach out and just call me at 248-792-3060. I'm always available to answer questions for people about anything and have a conversation that helps people sleep at night. So with that, the 5 reasons that that you shouldn't harm your loved ones during quarantine. And as I said before, we're going to have to change the name, when we go back to work next week. Those of us that are going back. But the 5 reasons are: protective services workers are essential. The police are essential. Our jails and prisons are a hotbed of COVID-19. Even now that we are moving forward, they are still places of devastation and poor health care and poor conditions as far as disinfecting and cleaning. And then number 5, parents can get in trouble for kids being kids. I'm sorry, that's number 4. And number 5, very few people, if anyone, looks good in horizontal stripes. So with that, I hope you all enjoy this beautiful day. Stay healthy, stay home, find some happy today, and I will see you tomorrow as we continue talking about domestic violence. Have a great day.